Sorry about that.
That's okay. And while I was in law school, I focused my time and attention on securities law, estate law, and tax law, and that is what I have done for the last 20 years for individuals, small businesses, and institutions, whether it be investment advising, financial planning, tax planning, and estate planning. That's primarily what I've been working on.
Yeah, very cool. It's an exciting topic, estate planning for sure, and so thanks for you all for joining us. We're going to record this as well, as you probably just heard. So we're going to try to give a big, broad overview today, but we're also going to get in the weeds on a few things. So hang on tight. We'll try to get through this in a entertaining as fashion as possible, right, when you're talking about death and estate planning. But all right, let's see here. Before we move on to the next slide here, check in with my messages. Okay, got it. Thanks, Kevin. And let's see here. So basically, big picture, what is estate planning? We're going to talk about the things on here. We're going to first talk about what is estate planning. We're going to talk about the documents that everybody should have. We'll talk about trust briefly. Trust we could talk about for days. Mm-hmm. We're not going to do that. We're going to give a broad overview and then talk about who in general may need a trust. What are they good for? We'll talk about estate, aka death taxes, and which states have them, who might be subject to them. And we're going to talk a little bit about, or Kevin's going to tell us a little bit about estate planning and wealth planning and some tax topics to think about as well. So firstly, Danielle, estate planning, and again, we talk about this vague phrase of estate planning. What is it? What does it include? And what are the specifics?
Okay. Well, I think that some people mistakenly believe that estate planning is limited to wills. And then also some of those people think that wills are not necessary if they just want to leave everything to a spouse, or they don't think they have very much. And estate planning is much more complicated than that. And it doesn't have to be complicated, but it's very practical. It's something that applies to everyone. And whether that means that you have 1 or 2 documents or 6 documents that all kind of fall under an estate plan, it is something that everybody should be thinking about. And so when we say estate planning, it's not just planning for death, which sounds very negative and very final, but there's also a lot of documents that will apply to you while you're alive. And the whole point of all of this, of course, is to make things easier and possibly cheaper for everybody in the long run.
Yeah. And estate planning, like you said, is not something that's reserved for just the wealthy, or if you have a large, massive estate. Everybody needs some portion of estate planning.
Correct.
So, we'll talk about what is estate planning. So we talk about why it's important. And one of the things that we like to do a little bit is share some stories and how we can learn from dead celebrities on why estate planning is important. And we'll just give a couple quick examples. We've got an article here from everplans.com, and they're just a service that helps you to organize your information online so that if something does happen, things are quickly available to you. But basically, one of the stories was from Bob Marley, and Bob Marley did not even have a will. So obviously that's important, but Bob Marley's family members were still filing lawsuits against each other a full 30 years after his death. So get your basic will done, because when people have passed away or something terrible has happened, the last thing you want to be worried about is a will when you're grieving a loved one's death. Regardless of your age, estate planning is applicable. One of the success stories is Paul Walker from the movies Fast and Furious had an estate plan and a will at age 28. However, when he died at age 40 in a car accident, he didn't change his will. Mm-hmm. So basically $25 million did not go to his teenage daughter. So luckily the grandparents they did the right thing and fixed the problem. But that can be tragic as well. If your life changes and you don't make changes along with it, then that's not a good thing. So basically, another story, we've got Philip Seymour Hoffman forgot about tax effects when you're talking about estate planning. He left about $35 million to his longtime girlfriend, and basically because he didn't take taxes into account for his estate plan, left about $15 million of his estate to the government when he didn't have to. So it's something to think about. Even if you don't have that kind of estate, you still need to talk about it or think about estate taxes, and we'll talk about it. Think about this in a lot of detail, like you're going to talk about today. When you make an estate plan or will or documents, living wills, whatever that may be, use a lot of detail. For example, Muhammad Ali spent 10 years allegedly, with his lawyers hashing out his multi-day memorial, which included a cultural festival, Islamic funeral prayer, and a flashy public memorial in Louisville's KFC Yum Center. I remember this one, Danielle, because my family is in Louisville. It shut down the city for a year or so. I think Kevin has the same plans for Knoxville, so he's got these plans underway.
Well, he should.
Yeah, he should. And lastly, they have an example of Paul Newman. He didn't communicate anything in his will or estate plan to his family, and so people were shocked and dismayed and upset at his death because they didn't know what to expect. So once you have your estate plan, your will organized, you need to communicate those things to your loved ones so no one is surprised or hurt, and you don't leave a mess behind when you pass away. So those are at least some hopefully entertaining stories we can learn from celebrities. If we can learn anything at all from celebrities, maybe that's something we can learn from them about why it's important. But otherwise, we know that just as the examples that we read, when something bad happens, we're in a state of mind that is
or not.
You who knows what your state of mind might be, but you definitely don't want to have to be worried about documents, money, where are things located, who are beneficiaries. It's too late at that point. So you want to get everything in order before this happens, regardless of your age.
And the first element you have on your slide there is state of mind at death or disability, and we always encourage people to have these planning discussions before something bad happens, because you really just don't know how you're going to react. And sadly, I have firsthand experience with this. When my mother was diagnosed with ALS, she passed away within 8 months, and she was in denial the entire time she was sick and kept hoping that she would get better, and we never once had a conversation about her death in that entire period. And thankfully, we had plenty of conversations before that when she was well, and she was a great client. She did everything I told her to do. So we had all of our affairs in order, and I never had to feel pressed to have that conversation with her because I knew what her wishes were. And thankfully, we didn't have to have that difficult conversation. And it's traumatizing to have to go through that with a parent or a sibling or a good close friend and have to ask these really what seems like insensitive questions at a time when it is extremely stressful. And it's better to have that plan, have that conversation now. And whenever I sit down with clients, I always say, when are we bringing your kids in here? And they kind of look at me like, oh, I don't know if I want to talk to this about them. And you don't have to give them all of the minute details of your documents, but at least have a conversation, because I can't tell you how many people have never had a conversation of any kind, and that is a very slippery slope, and it makes things so much harder. So we recommend having those conversations in general.
That's an amazing lesson. And what caught my attention there was you talked about, once your mom was sick, even though there was still time, it's still too late. I mean, because they're not in, their state of mind is different, and you certainly don't want to be talking about those things when
you're actually dying.
When you're very ill. So into some more details, and on that note, what are some of the documents? And we say before going on vacation, kind of ingest a little bit, because you want to make sure everything is okay anytime, really. But what are the documents?
Yeah, this page does a good job of giving you the very basics of what pretty much everybody should have. Everybody should have some sort of a will. And I hear all the time, even from family members, well, I don't need a will, I don't have anything, or it's just going to go to my mom, right? And that's not necessarily true. Every state has a different set of rules. And you might think that if you're a married person, everything goes to your spouse, but most states, that's not how it goes. Part of it goes to your spouse, and part of it goes to your children, whether you want it to or not. And if you are remarried or you have multiple children or multiple marriages, it makes that all the more complicated. So even if you are a single person and your intention is for everything to go to your parents, or it's still a good idea to have a will. And part of the reason for that is you have to have a will to submit to the court. If you do not have a will to submit to the court when you pass away, which is called probate, if you do not have a will, then everybody's going to court. And you have to go before the judge and get the judge's permission to do all these things that you could have easily addressed in a will, very easily. And unfortunately, now you probably have to hire an attorney. And when you get courts and attorneys involved, just crazy things happen where everything gets blocked up and it takes forever. So you now have months and months, if not years, to get through something that could have been very easily handled in a simple document. The durable power of attorney is for property. That can be used at any time for anyone. You could be going on vacation and expecting a real estate closing, and you could ask your friend to sign on your behalf. You could, and that could just be one item, or you can have something as much as what I call a kitchen sink that you have for your spouse, that if something were to happen to you, either you're on vacation, you're in a coma, you're incapacitated in some way, your spouse has the ability to handle whatever they need to financially. And you have to keep those up to date. Durable power of attorneys, banks and other financial institutions don't really like it when they're 15 years old. Mm-hmm. So I recommend that you get those updated pretty frequently, maybe every 5 years or so. You don't have to file it with the clerk. You just have to have it on hand. And the advance directive is for healthcare. That includes nominating someone to help make decisions on your behalf if you're unable to make them for yourself. And it also addresses that living will. A lot of people think of it as a DNR. If you end up getting diagnosed, sadly, with a terminal illness and the doctor says there's really nothing else we can do at this point but to make them comfortable, how long do you want to be on a machine being comfortable? Mm-hmm. That's a difficult decision to make. Again, these can be written to say whatever you want them to say. So I don't encourage people to get just blank forms offline. I've had to look at several of them over the years. They don't address what they need to be addressed. They don't have signatures where they need to have signatures. And bad things happen, and it's really not expensive to have an attorney look at this for you and get it done right. The important thing on the will, the power of attorney, and the healthcare directive is that they can be changed at any time, and they should be. Anytime there's any kind of a change in your life that dictates any kind of a change in your document, you should make sure that you do that. So that's something that I recommend that everyone have. You can get more complicated depending on the state or the family situation, and that's when we kind of get into talking about trusts. But the other important information you have listed there is making sure that passwords are available nowadays. If someone passes away, you can't just hang out by the mailbox and wait for things to show up. Because that doesn't really happen anymore. So I always recommend that when people have their documents completed, that they have a list of passwords, account numbers, locations, phone numbers, and that they keep that list updated and keep it somewhere safe, preferably in a fire safe box in their home, or somewhere that somebody knows how to get to it.
Yeah, those are awesome. And it's sometimes we overlook the simple things in estate planning because we have the complicated trust, we have the complicated durable power, or the seemingly complicated stuff. Mm-hmm. But it's the simple stuff, being organized and allowing, if something happened to you, can your spouse get to this information? Can your spouse log on to your bank account or call your insurance person or financial advisor for help? And having someone there as that middle person could be helpful. And like you said, a vault in your house, or we even have an online vault we can use for folks if they want to store secure passwords. We personally use a password manager as well. So
another really important point to remember for the will, for durable powers of attorney and healthcare directives, you can usually use a copy, even an electronic copy. A will, when someone actually passes away and you need to go to the probate court to submit that will to the clerk, it has to be an original signature. So I always tell people to sign in a bright color, make sure it's blue and not black, because I've had issues where clients have come and said, the clerk won't accept this. It's in like that skinny black pen, and they don't believe it's original. And it's a fight. So I recommend that those wills are original, that they are somewhere you can get to them, because it doesn't help if you have one and no one knows where it is. But make sure that will is the original copy of that will is on hand. Yeah.
So basically, just to recap a little bit, don't get your wills and trusts done at Office Depot. I've had attorneys like yourself tell me that that's their biggest source of business is, defending or those things go to court, they get challenged. Also have your documents in a place where they can access. And we talked last time about not having them at a safety deposit box at the bank, right? Because who knows who can get there.
Yeah, banks tend to be open 9 to 5, and death and trauma doesn't always fall on bankers' hours, and you need somebody to make sure that they can actually get to the bank to do that. So I recommend that you not keep it in the safety deposit box, but a home fire safe might be a good place to put it.
Okay. And let us know if the audio is still okay. We've got a message that maybe we've broken up a little bit or the audio doesn't work. So let us know through the messaging if it still sounds okay. Otherwise, we'll try to do some troubleshooting on our end. Let's see here. So basically, we're going to talk about, we're going to kind of shift gears here a little bit and talk even a little bit more technical stuff. And this is really important to me, even though when you first put this up here, I was like, oh no, these big words, I don't like them, and I start to get sleepy when I say these big words. But basically, this is important because
I wish I could make it simpler.
You can.
I really can.
And I can only try to add a little bit of entertainment as we go by making fun of Kevin, but basically, this is important because you need to know what's going to go through probate, meaning the probate court, or what's going to automatically go to your spouse or your children or your heirs, whoever that may be.
Or as automatically as
as automatically as possible. And to me, a good example of that before I hand it off to you is if I have a beneficiary, that account or property or whatever it may be is going to pass automatically by contract of law. It's not going to go through the probate court, whereas my home probably will. But Danielle, take over from there. What can we learn from this one?
So our goal in estate planning, we have two types of estate assets. One is something called probative and one is non-probative. And I start with non-probative because basically anything that goes to probate is anything that's non-probative. So if we start with non-probative, that means that these assets can be distributed to beneficiaries outside of the court. So you have beneficiary designations on your retirement accounts, your 401ks, IRAs, Roth IRAs, life insurance policies. Anytime that a company asks you to fill out that cumbersome little beneficiary form, take it very, very seriously. It's easy, it's free, and it is something that you should keep up on no matter what's going on. Sorry, we're having a little technical issue of our own where our phone battery is dying. You got it? Sorry. Okay. So that way, what happens with those types of assets is once you have a death certificate, which takes anywhere from 2 to 6 weeks, depending on where the person's passed away, you can submit it to the insurance company, the IRA company, wherever the account is, and that money can get distributed to those people directly. You don't have to wait 4 to 6 months in probate court, which is what will happen if it doesn't, if it gets passed outside of those documents. Another way of getting assets out of probate is by holding them jointly. Obviously, a spouse is the easiest example here. If you have a home or bank accounts or an investment account that's all taxable, that's held in joints with rights of survivorship, so joint tenancy with rights of survivorship. Sometimes you see it as TROS, I think. You'll wonder, what is that? TWRS. That's what that means. It means that if one spouse passes away, it automatically passes to the other. Then that second spouse now has an account singularly, and the other way around that is to have a pay on death. You may have heard of that on a bank account, or if you have a Schwab account, if you have a taxable Schwab One account, you can use a transfer on death designation, which is basically the same thing. It's like a beneficiary form for a taxable account. So if the husband passes away, leaves the wife, and the wife says, well, I want everything to pass to my son, but I don't want my son's name on the account right now, you can fill out a transfer on death or a pay on death form and add it to your son so that those assets will automatically go to your son. If those things are not going to be handled through the probate court, that money can be gotten much quicker. If you have to go through probate, for instance, in Tennessee, it takes 4 months to get any of those assets. You take the documents that you need to the clerk. They file a letter with the newspaper and tell the creditors of the world, hey, this person died. You've got 4 months to make a claim against the estate, but the beneficiaries don't get their money until those claims have been satisfied. So it's very important to have non-probative assets so that there's cash available to pay for things and to give money to beneficiaries who might need it and to pay off hospital bills and anything else that comes up. And once the court determines that those bills have been paid, then you can do distributions. But for some people, 4 to 6 months is way too long. And so as much as you can have that is non-probative, the better. So then we move on to probate, which we've kind of already covered. And probate is going to be anything like if you own a home singularly or you own bank accounts, you're the only one on it, and you have not added a joint owner on those accounts, that will go through probate. Your cars, it's pretty hard to get around cars unless your spouse owns it with you. Other personal property, furniture, clothing, things like that, they're not usually a big deal. But if there's really no money and there are bills, the court is going to look for everything they can get their hands on. So that's what probate. That will be what's considered probate.
And so probate, I mean, we're going to talk about trust in just a second here, but probate is not always such a bad thing. I mean, if you have a simple estate, and again, we'll talk about the pros and cons next about trust versus probate, but it does make things simpler. And just as a quick overview, basically retirement accounts are going to go via beneficiary. That's outside of probate, so that's quick and should be fairly easy. Life insurance will go via beneficiary. And then, like you said, joint brokerage accounts, such as at Schwab, you can, if you want to, they can either be joint tenancy, like you said. One person one time said, "Hey, who's JT Ross?"
Yeah.
That's joint with
rights of survivorship.
Yes. So that makes things easy.
And that should be answering that question that just popped up from one of the clients, that if the property is held joint tenancy between a husband and wife, the spouse that hasn't passed away automatically gets that. It doesn't go through probate court. However, when that second spouse passes away, it could go through probate court if they don't add another person onto that deed.
Yeah, so hopefully that helps and reattack there if that doesn't help there, Bob. So thanks for the question.
You're welcome.
All right. Let's see, here we go. Okay, now, just as I kind of alluded to earlier, we've got tons of trust. We're not going to talk about all these, Danielle, but in the next slide, we're going to even talk about a few more specific situations. But in general, a trust is where you can kind of make laws after your death, express your wishes, if you will, after you die, such as, I think one of the most common ways to do this, especially, is let's say you have a blended family and you have stepchildren and half children, and you're able to say, okay,
I'm not sure half children is a word, but I kind of like it.
Half siblings, that's what I mean. I have half children. But anyway, so basically, especially if you have children that are under the age of 18, you can say, I want Jimmy to get some money when he's 18 or 21. When he goes to college, he'll get a little bit. When he buys his first house, he'll get a little bit.
And you can do that without creating a trust before you've passed away. There are trusts that you create before you pass away, and there are trusts that magically come into existence once you've passed away, and you can put those in your will. And whenever I have a client who has young children or grandchildren they want to provide for, that I include what's called a testamentary trust in their will. We don't have to go through the rigmarole of creating some big complicated trust while they're alive, because maybe they just don't have that much, or it's not really an issue of privacy or estate taxes or any of the other issues that trusts help. But you can add a testamentary trust to a will that will cover minor children pretty easily. It doesn't need to cost a bunch of money. Estates, probates, and trusts are all dictated by state law, so it really depends on what state you live in about what you need more of, what complexities you require and what you don't. Tennessee is very simple. I come from Illinois. Illinois is a bear. I know that's shocking. But Tennessee is actually a pretty easy state to do probate. So if you truly don't have a very complicated estate, a will may be plenty. You may not need more, but if you decide to create a trust while you're still alive, it's called a living trust. There's something that makes sense and is easy to understand. And it doesn't do anything except create a document that goes into effect upon one or both of your deaths, meaning a marital trust, that is. And so if you're married or if you're a single person and you want a living trust, that trust simply means that upon your death, the terms of the trust will go into effect. And that is also non-probative. It will get it out of probate court. So a trustee, whoever that person may be, gets to start distributing assets right away. They don't have to wait for that creditor period. However, if there are creditors and there is no money in the probate estate, they can still come after trust assets. And I don't want to go any further on that, but the point is that trusts are not magical. They don't hide taxes. I get that a lot. Oh, if I get a trust, will I suddenly not be paying taxes? No, absolutely not. You're still going to be paying everything under your normal Social Security number. Everything that you own, even if it's technically owned by the trust, is still owned by you personally, and you'll still be responsible for any taxes throughout your life, just like you are now. But when you pass away, or when both of you pass away, if it's a spousal trust, it now becomes irrevocable. That's number 2 on your list. And that means that the trust is now an entity of itself. It gets its own tax ID number. It has to file its own tax return. And trust taxes are much, much, much higher than individual tax rates. So unless we know some clients who they have a bunch of kids, they have a bunch of money, and they pay trust taxes because they feel that strongly about not like independently making their children independently wealthy overnight. So you have choices. You have a lot of choices when it comes to trust, and you can have them for a lot of reasons. You mentioned in there a spendthrift trust. You've got a kid who is up to his eyeballs in debt. The IRS is after him, so you want to hide that money in the trust for him, and he'll get it over time. You can have a lot of different rules. But the rules in trust have to be very general. You can't say, I only want Michael to get my money if he marries a good Jewish girl. You can't say that. They call that dead hand. It's against the law. They don't like it. It's against policy. So you can have basic things. You can say, I don't want Michael to get more than this much money by the time he's 30, then 35, then 40. And in the meantime, anything out of the trust can be spent on his health, welfare, maintenance, and education. So you can be that general, and it still protects money for Michael in the event that he has some issues. And I apologize to any Michaels out there. But,
and all the guys, too.
Yeah, and special needs, that comes up a lot with children who may be autistic or have mental or physical disabilities, and they'll need help for the rest of their lives, that those should be put in there, too.
Yeah, and I jumped ahead a little bit quickly there on the next slide because I think there's some overlap. But like you just said, we really don't do trusts anymore to avoid estate taxes.
Right.
Just because of the current estate tax laws are such that unless you're again a husband and wife or a couple that have an estate exceeding $22 million, then you're not really right now going to have to worry about federal estate tax.
No, and that is set to eclipse in 2025. We'll see what happens, but estate taxes really affects a very, very small percentage of the United States population, so we don't spend a whole lot of time on it anymore. Our next slide will show that most states have gotten rid of estate tax, so that's really not the big issue. Years ago, when I was first in law school, it was a very big issue, so we talked about it a lot, and I'm honestly thrilled that we don't have to talk about it very much anymore. It was very complex, and it made all kind of, lawyers love making things complex, and I have something in my body that likes to keep things simple. So I'm thrilled that we don't have to use trusts for that issue anymore. And now trusts are really most important for privacy issues. If you have property in multiple states, because if you do not have a trust and you say you have a second home in Florida, but you live in Tennessee, your family is going to have to open a probate case in both Tennessee and Florida. It's a pain in the neck, it's expensive, and it's time consuming. So if you do have property in multiple states, something simple in the way of a trust might be good for you because it will just make things that much easier. And before we go past trust, the important thing is to say that just having a document that says the word trust at the top does not mean you have a trust. You have to fund the trust, and the way you fund the trust is by changing the names and titling your deeds and your investment accounts and things in the name of the trust. So it's very simple. You take your trust document to your bank, you take it to the title company, you get your assets retitled into the name of the trust, and now those things are owned by the trust.
Danielle, how often have you seen people go through the trust paperwork, pay the attorney, and then the trust never gets paid?
Oh, lots, all the time. I mean, one of the first things I do when I sit down is, we have a trust. I'm like, well, let me see it. And then I go, okay, what's in the trust? And they stare blankly at me. And let me see your deed. The deed is not in the trust. None of the bank accounts are in the trust. They truly have no trust. So it's important to get those things titled right away and to keep up with them.
And I blitzed ahead on just to show the map of the state or inheritance tax. There's not that many anymore. But one question too, before we even talk to that, if at all, what do you think about? We know the estate tax laws are going to sunset in 2025, I think. Should people go out in 2024 and get the old AB trust so they can avoid any potential, or do you wait till the law changes? How do people typically handle that, or is there a way? There may not be a way.
In some ways, it's a good thing that Congress is as slow as it is, because we get to hear about it for like 2 or 3 years before a law actually has to get changed, and so we have some time to think about what we think might happen. Another way to help deal with that now is to just slowly start giving some gifts. I mean, is there a reason that if you really want all your money to go to your kids and you have plenty of it, is there really any reason to not start giving some of that money away now, whether it be to children or relatives or family members or charity? There's nothing that says you have to hold on to it forever if you don't think you're going to need it. But I've seen people all over the spectrum on that too. People who have millions of dollars sitting in the bank, terrified that they're going to run out of money any day now, and they're 89. So it really just depends on the person, what they're more comfortable with, and what will work for them.
Yeah. And just to talk a little bit here to the slide we have up, there's just really not that many states that have a death tax or inheritance tax anymore. Your home state of Illinois looks like they still do.
Yeah, because they're broke.
My home state of Kentucky still has one, of course. But a lot of these have been phased out over the years. And do you think these will continue to be phased out in case some of our listeners are from these states, or do we know?
We really don't know.
No,
I mean, it depends. If they have a state tax, there's probably a reason for it.
Yeah.
They're probably relying on it for some reason.
Yeah.
They may have they have a lot of millionaires in that state, and they rely on that money. It's really an individual decision. I'm kind of surprised at how many have gotten rid of it, to be honest.
Just come on down to Tennessee.
Mm-hmm.
So basically, again, continuing on the tax thing, I think this is about the time where we hand it off to Kevin, if I'm not mistaken. But we've talked about a couple of things already. But Kevin, if you're with us, and you can kind of jump in here, I know we've got some information that you would like to talk to, and tell us when you're ready for that.
Sure. Can you hear me okay?
Yeah, we got you loud and clear. So did I have you start at the right spot, Tom?
Absolutely.
Right.
And first of all, Danielle, thanks so much for the information. And if there are things that I'm presenting here that you can add some color to, happy to pause and let you jump in. Charlie makes a lot of fun of me because I really like the details. I like, I'm going to say I like tax, but I really like when we can help people pay less tax. And so that's really the focus of this. The other thing I'll just say before I get started is when you think about Charlie's battery running down on his phone, I will tell you he does have a little bit of an excuse. He flew 2 planes today, and he drove back from Atlanta 3 hours. So, Charlie, we're happy that you're with us as well.
Thank you.
Okay. Yeah, so let's jump into it. So really my mission here is just to let you all know some of the strategies that are out there. It's not for you to totally get the strategies. We can talk further about these strategies. If something is really interesting to you, we're happy to talk about it. But with that $11,180,000 exemption now, I heard a webinar last week, and they said only 1,800 people are going to be having to file estate taxes that have more than that amount of money per year. So with that being so high now, people are not worried about that as much as they're worried about income tax planning. So estate planning is now income tax planning. So the first strategy is generational planning. What's generational? We can hear you laughing at me. I'm not sure if you guys are on mute.
I was just trying to jump in on something real quick to say.
Go.
Okay. We talked about, you triggered it for me when you said filing an estate tax return. And just because you don't owe estate taxes, you still need to file an estate tax return for a decedent. So I just wanted to make sure that was out there so people didn't forget about it, because you still have to file even if it's zero.
Yeah, great point. So, okay, great. So the idea here, I'm going to talk about the parents as being mom and dad, and then I'll talk about the children as being children and grandchildren, obviously grandchildren. But we're talking about generations. Now, the interesting thing for us is that sometimes mom and dad are 90 and the children are in their 60s and the grandchildren are in their 30s and 40s. So, the definition of parents is maybe not usually what we think of. But anyway, so the idea here, and if you can go to the next slide for me, Charlie, with the actual tax rates. So what if mom and dad have an income of $100,000, and that's the 12% tax rate, if you can point to that. So the 12% tax rate, if you have $100,000 of income, and now you have that $24,000 standard deduction, mom and dad are only paying 12% tax, okay? So let's say that mom and dad live in the state of Texas, and they're in the 12% tax bracket, and their only child is in, we'll use Chicago, Danielle, for you. Their only child is in Chicago, and they're a neurosurgeon, and they're in the 35% tax bracket, making $450,000 a year. So what mom and dad can do is they can make sure that they fill up their 12% tax brackets through different strategies, such as taking IRAs and converting them to Roth IRAs. So basically, the tax lingo is that they can do a conversion to a Roth IRA and they can realize the income. So this is what we call a tax arbitrage, because parents are paying 12% tax. The money is going into a Roth, and if the rules of the Roth are followed, nobody has to pay tax on that money ever again. So mom and dad pay the tax. They give the gift to their child when they pass away, and their child, who's a neurosurgeon, maybe still needs the money, but they're not going to have to pay 35% on the money. Not only that, they're not going to have to pay Chicago tax as well as Illinois tax. I don't know if there's Chicago tax, but in some states there are city taxes as well. So that's really the first strategy, is to think about the difference between what the parents are paying and what the children may pay. Any comments on that, Danielle?
I just get excited when you talk about Roth because I love them so much. But no, I agree with everything you just said. That's fantastic. And there are so many different types of accounts and so many things that you can do with what you have to make things better for everybody. And it's just a matter of sitting down with somebody who knows what they're doing and moving things around. And I tell people over and over again, I work with tax clients, I work with investment clients, I work with estate clients. It is so much cheaper to do it right the first time than to wait until it's been messed up. And to fix something is always so much more complex and so much more time consuming and so much more expensive, especially when you're dealing with the IRS or something's happened after nothing can be changed. After someone's died, there's nothing you can do. So I always just tell people, spend a little bit of money talking to a professional now and know what you're up against and get things in order. It will save everybody a lot of time and tears and money later.
Yeah, thanks for that. And Charlie, if you can go back to that tax slide, the next strategy, if you can go back just one. There, perfect. The next strategy is when two spouses, one of the spouses is sick and they're currently married filing jointly. And let's again go with that $100,000. So once again, we're in that 12% tax bracket if they're making $100,000 minus the $24,000 standard deduction. Okay, and let's say one of the spouses is terminally ill, and I know this is not fun stuff to talk about, but if one of the spouses is not going to live for a long period of time, again, this type of a situation, you may want to consider Roth conversions. And the reason is if the income is exactly the same when the first spouse dies, now draw a line on the 24 tax bracket where $100,000 as a single person is in the 24% tax bracket. So we're talking the potential to get some income taxed at 12% instead of having the spouse that's left have to pay, 1/4 of the money goes to taxes. The big change in the tax code from last year to this year was that the marriage penalty for most of these tax brackets is gone. That is, if you take the single rate and you multiply it times 2 when there's 2 people, it actually matches up for all the tax brackets except for the 37% tax bracket. So because of this, I really think couples, and even if one is not sick, you can still do this kind of stuff and just know that, hey, we're going to pay 12% tax, we're going to get money into the Roth, and we're never going to pay tax on that money again. So thanks for that. If you can go to the next slide, please. The other thing, and Charlie, you can chime in here as well. Those tax brackets that you just saw, they always quote the highest tax bracket, and they say 37%. Well, that's not the lowest tax bracket in history. But if you look at those tax brackets, the mid and the lower tax brackets are among the generational lowest tax brackets that we've ever seen in our life. So there may be a time to actually pay tax now. Not always, but sometimes. Charlie, what do you think about that?
Yeah, I think it was the 70s, right, when the marginal tax brackets were 70% plus. I mean, I don't think we're going to go back there, but you're right in that with the tax reform law that was just passed, it makes even more sense now than it did before to try to get money in Roth somehow, some way, whether you're retired or whether you're still working. There's always pros and cons that you have to think about as far as your current tax situation, but like Danielle said, in a real nerdy kind of way, we love the Roth. It's just amazing. So take advantage of it while it's still around.
And I would also say that when I talk to clients, one of the things I make them repeat is that tax deferred is not tax free. And I hear that all the time. Well, I don't want to pay the taxes now. Well, it might be better to pay the taxes now. You're never going to, people tend to think if they're not paying it now, that it's like never going to show up. And of course it is. But now you've lost the control about whether or not it was better to pay it now or later.
Great. Thank you for that input. The next one is RMDs. And for those of you that are young, that are listening to this, it's not going to happen for a long time. It's not until 70 and a half, and RMDs is short for required minimum distributions. And so we must take money out. The IRS gives us one break when we're young. We save money in 401ks, profit sharing, et cetera, but we must take the money out when we get 70 and a half through the rest of our lives. And so the idea here is that you can have a person that retires in their 50s or 60s and brags to their friends about how little tax they pay because they have their big IRA and they have some money in a taxable account. And then all of a sudden they hit 70 and a half and their $2 million IRA all of a sudden starts spitting out 3.5%, 4.5%, 5.5%, 6.5% of its principal. And all of a sudden the person goes from sticking their tongue out and making fun of others to now having to pay a lot of tax. So this is, we call it flying below the radar or smoothing. So instead of waiting till the D-Day where you're going to have to pay at 70 and a half, maybe doing some tactical Roth conversions in 50s or 60s, if that's when your income is lower. And again, filling up those lower tax brackets. And the way to do this is to project taxes into the future years to try to minimize. And again, if you all have any comments on that one before we go to the next.
No, Kevin, you made a great point in that obviously our required minimum distributions are at 70 and a half, but if we can start planning early, which we do a lot, then you can have a huge impact. You know, with someone in their 40s, 50s, even early 60s, you can really design good tax diversification so that they'll pay lower taxes for the rest of their retirement, and we hope to be in retirement for a very long time.
Terrific. So the next strategy is gifting versus the step up in basis. And I'll use an example. Okay, let's say that mom and dad bought Amazon at $5, okay? And Amazon is now, I think it's about $1,750 a share. So that's what we call a huge unrealized capital gain. So if mom and dad gives Amazon stock to their kids, the kids actually end up also getting the gift of unrealized capital gains. So sometimes it may be better to hold on to stock or funds until someone dies because they will get a step up in basis. And the step up in basis just means that when they sell Amazon, if it's still $17.50, their basis is $17.50 and there's no gain. So this whole idea of gifting, it's very important to decide what you want to gift versus what you want to hold on to. And the other issue, you know, we don't want the tax tail to wag the dog. You don't want to hold on to a stock that goes to zero because the company failed and you didn't want to pay taxes on it either. So there has to be some middle ground, and I'll pause to see if Danielle, if you have any thoughts on this.
Yeah, I get a lot of people saying if I want to sell something, for instance, or if I recommend that they sell something, they're like, oh, but I don't want to pay the taxes. Well, if you don't take the gains, you're not going to get anything, you know, because don't give up 80% or 85% of something because you don't want to pay tax on it. And one of my favorite examples is I had a client who owned a particular security, and it was getting ready to pay a large dividend, like an exceptionally large dividend. And the salespeople from the mutual fund that the dividend was coming from came in and said, oh, there's going to be a really big dividend. You guys should sell now so you don't have to get the dividend. And I said, why on earth would you give up 60 to 80% of your dividend in order to not pay a little bit of tax? I've never understood that, and a lot of people are so adamantly opposed to taxes that they will cut their nose to spite their face, and that just doesn't make any sense. It doesn't make any number sense. And so I try to remind people to be unemotional about it and just look at real numbers and stop thinking about this idea of taxes that you really don't have that much control over.
Thanks for that. And Charlie, if you can go to the next slide. I think we just have a couple more here for me, and then we can take questions. So 529 plans. Now, when you hear 529 plans, what should pop in your head immediately is it's for college, okay? But I would suggest that 529 plans are actually an estate planning item as well. So mom and dad, maybe it's grandma, grandpa, that is mom and dad, can gift money. It's one of the only things I know in estate planning, and Danielle, please correct me if I'm wrong here, but it's one of the only gifts that you can give that can be taken back, okay? Most of the time when you make a gift, and if I was to give Charlie $1, that dollar is gone. It's no longer in my possession. It's now with Charlie. But with the 529 plans, you can actually make a gift to children and grandchildren, and you can always take that money back. And the reason I suggest this is sometimes people don't want to make a gift because what if I get sick? What if I have to go to long-term care? Well, if that happens, you can take the money back. The other part of this is you can fund up to 5 years in advance. So 5 years per person. So if mom and dad, that's two people, they could fund $75,000 a year per person per child. So that would be $150,000 that they could put in a 529 plan for a child or a grandchild. And again, it will grow tax deferred. If the money does need to be used for something other than college, then the earnings will be taxed and there will be a 10% penalty. So there is that, but the money can be taken back out that's put in without having to pay tax. And then the law changed this year now, so grandma and grandpa, mom and dad could pay for private school for grandkids now, up to $10,000 a year. So the 529 plan, again, we think of it just, hey, I'm a young parent, I got to save for my children, but it can also be an estate planning item. The final one, and then I'll ask for comments from you guys. The final one is qualified charitable distributions. Okay, one of the other huge changes is now the standard deduction went from $12,000, I think it's $600 to $24,000. So it used to be people would give money away, then they would deduct it on their taxes. Well, now that's extremely hard to do. So the better way to do it, and it's called a qualified charitable distribution, instead of you taking the money out of your IRA and then giving the money to charity and paying tax on the distribution, you have the IRA actually write the check to the charity. So you give your required minimum distribution to a qualified charity. So let me give you an example. I want to give $5,000 to my charity, and I have $100,000 of income. If I go ahead and take the money out of my IRA, I now have $105,000 of income, and I have to pay tax on that other $5,000. Instead, what I do is I have my IRA, and Charles Schwab will do this, write the check to the charity, and that $5,000 of income does not even hit my tax return. Doesn't hit my tax return, I don't have to pay any taxes on it. So with that, I'll turn it back over to Charlie and Danielle for any comments on the last two and closing statements. Thanks so much for allowing me to talk about these things in the weeds, and I'm very happy to talk further if anybody would like to.
Awesome. Thanks, Kevin. And just to clarify one thing, and that was the new tax reform law in the 529 plans. Kevin, you mentioned private school, and to be more specific, it's actually the secondary school. Other than just, 529 used to be only for college. The new law allows them to also pay for secondary school. I think I'm using that term correctly, high school, private high school, elementary school, up to $10,000 a year. And that may even also be state dependent too. So double check your particular state for that as well. But awesome, Kevin. Thanks for doing that.
Yeah, the other we talked about RMDs for when you reach 70 and a half, but it also impacts young people who have inherited an IRA from a parent or something. You can take those, especially if you're still working and you're in a high tax bracket and you're already giving money to charity, and you can no longer deduct it on your itemized deductions because your itemized deductions are so high. It's a great way to use that IRA distribution that you have to take anyway and kill two birds with one stone without costing you any money.
Awesome. Thanks, Danielle.
That's a great point, Danielle. Thanks.
Yeah, and so if anybody has any questions, of course, I think we have one more question we'll take a look at. But we also have Danielle's website for her business. Actually, we don't have the website. We just have the name of your business and you and your partner's email, along with myself, Kevin's email. So if y'all have any questions at all, please don't hesitate, obviously, to ask right now or follow up after this if you think of something later. So one question we have is, do any 529s qualify as qualified charities? I think the answer is no, but I'm not sure if I understand the question completely.
No, I think
Charlie?
maybe what they're getting. Can you?
Yeah, go ahead.
Yeah, I was wondering if maybe they're thinking about the donor advised funds.
Oh, maybe so. Yeah.
Viewer number 10, are you thinking about donor advised funds, or are you thinking about a different program? Go ahead, Danielle. You had a comment.
Oh, I was just going to say that I think maybe they were thinking you could take money directly from the IRA to a 529 plan and it would also qualify. But
that's probably right.
That's my guess,
Yeah.
and I don't think so. But if you want to talk more, I don't know as much about donor advised funds as Kevin might. So yeah, an RMD to a 529 plan. I don't think so, but Kevin, go ahead, and if you know more than that than I do.
Yeah, that's correct. Unfortunately, I love the idea. And I love the creativity, but unfortunately, I don't think that would suffice. You could take the RMD, pay tax on the money, and then go ahead and put it on into the 529 plan after you pay tax. I know for a lot of people that are very wealthy, they do that. They're not going to use their RMD, so they take the RMD, they pay their tax on the money, and then they go ahead and fund 529 plans. And as you're stating there, you know, you're saving tax, or you're tax deferring in the IRA, and then when the money goes into the 529, you're once again tax deferring. So I do think that that's a reasonable strategy, but you do have to pay the tax between the RMD and the 529.
Yeah. So it looks like that worked. And just with a couple of minutes we have left, I'd like to just piggyback on what you alluded to earlier, Kevin, and talk about, we talked about how much we love the Roth, which is a wonderful tax-free account, but we also love a taxable brokerage account, just your typical account that you might invest in at Charles Schwab or Fidelity. And because, there's a lot of great reasons, but one of them you alluded to earlier with that step up in cost basis at death. For example, I think you explained this well, but just in case, if you have $100,000 of Apple stock, you bought it at $50,000, your kids are going to inherit that, and they're not going to pay any taxes on that, basically, just to make it very simple.
Well, they can inherit it, not pay any taxes on it, then they can sell it and not pay any taxes on it. And it's pretty amazing. That's
amazing. So we love taxable accounts because you can invest very tax efficiently using ETFs, individual stocks.
And you guys keep talking about stocks, but I think one of the most common examples of a problem a problem that's solved with a step up in basis is property. A lot of people will inherit mom or dad's house. Mom and dad had lived in that house for 30 years. The market value is way over what it was when they paid for it. And if they gift it to them before they pass away, or they add their child to the deed before they pass away, thinking that it's going to save them having to write that pesky will for $500, it turns out then the kid is like broadsided when they go to sell the house and find out that they have to pay a small fortune in taxes on that home. If they had just left it and let it pass through their will, then they would get a step up in basis. And I just had a client just called recently. He inherited a $700,000 house that his mother owned in Boston, and he was all worried because he's like, oh my goodness, she's had this house for 25 years. What am I going to pay? And I said, well, were you on the deed when she passed away? He goes, no, I got it through the estate. I said, well, perfect. Now you're not paying anything. So he was ecstatic.
Yeah.
So I hear that a lot, that people want to put their kid on a deed for their house so that they don't have to go to probate. Well, just have a will. That will help take care of it, and then they'll still get that step up in basis, and they won't be paying taxes on that house.
Yeah, awesome. Last slide we have here, and last note on the step up in basis in the taxable account is that we like annuities. Annuities are okay in certain situations, but this is one you got to watch out for, because if you take a taxable brokerage account and buy an annuity, then you lose your step up in basis at death.
They're very taxable.
So be very, very careful with that.
That phrase that tax deferred is not tax free.
Right,
annuities are huge problem with that.
Awesome. But finally, again, thanks for spending some time with us today. This will be recorded. We'll get it on our website. There's some other great resources out there, either through your employer. I know Southwest Airlines does a lot of estate planning for free for folks, just the basic stuff anyway. So maybe check with your employer on those. One of my favorite websites, Danielle, and I don't have it up here on the slide, it's actually gyst.com. gyst.com. It stands for getyourshittogether.com. And I'm being 100% serious. That is a great website. I'm totally serious right now, because it was a young woman, mother, wife. Her husband died unexpectedly. So she took it upon herself to make this website and just kind of talk about common sense estate planning stuff, because she was a young person and it happened. So check that out. There's other great websites, other great books, but of course, you're welcome to call us, email us anytime as well. Any final thoughts, Danielle?
No, I like I said, I think we've tried to hammer home that planning ahead and spending a little time and money now will be so productive down the road. And I don't think any of us in this room are going to sell things to clients that they don't need, and we'll be happy to give advice on whatever your situation is. But everybody's different, and I always recommend that you actually talk to somebody before you make these decisions.
All right. Thanks so much, Danielle. Thank you all for attending, and have a great day.